Loudspeakers are prohibited in the courtroom except as approved by the President of the Supreme Court chamber. 5. Smoking or bringing food or drinks inside the courtroom is prohibited. 6. All weapons, explosives, ammunition, and inflammable substances are prohibited inside the courtroom. 7. The use of cell phones is strictly prohibited. Phone, cameras, and phone audio recordings are also prohibited. 8. All persons are prohibited from changing seats or walking freely inside the courtroom. And 9. All persons are prohibited from clapping, cheering, shouting, or making loud noises. 10. Permission must be granted by the ECCC authorized security guard in order to enter or exit the courtroom. 11. Children under 16 years of age are prohibited from entering the courtroom. Persons between 16 and 18 years of age may enter the courtroom if they are accompanied by parent or legal guardian unless they are attending the public hearing as civil parties. 12. Pursuant to the internal rules of the ECCC and the applicable laws of the Kingdom of Cambodia, the President of the SCC may take preventive measures or direct action against any person who breaches these internal rules or regulations. Phnom Penh, 12 of November 2012, President of Supreme Court Chamber, Kung Srim. All rise. The President, please be seated. President, upon having been seized of the immediate appeal, the Supreme Court chamber pronounces the opening of the hearing to hear this appeal. The appeal is the immediate appeal by the co-prosecutors against the decision on reassessment of accused Ieng Thirit's fitness to stand trial of the 13th of September 2012. This appeal was lodged after the decision by the trial chamber was issued on the 13th of December 2011 in case 002/19 September 2007/ECCC/TC. During this hearing, the chamber will hear matter concerning as to whether conditions should be imposed on Ieng Thirit's release. And third party should be noted that the arguments to be raised during today's session are merely the matter as mentioned, in particular the grounds for the release and how they can be implemented and enforced. The composition of the Supreme Court chamber judges include Judge Kung Srim, I myself, the President, Judge Chandra Nihal Yashinge, Judge Saum Serevut, Judge Anishka Milad, and Judge Mongmani Charaya, Judge Florence Mumba, Judge Yanaran, Reserve Judge Sun Rit, Greffiers Mr. Siam Mao, Mrs. Annie Mary, and Mr. Pon Thun. Greffier of the Supreme Court chamber is now instructed to report on the current presence of the parties to the proceeding. Mr. Siam Mao. Mr. President and Your Honors, all the parties to the proceedings are present. On the prosecution side, we have Ms. Chawan and Mr. Andrew Cayley. And the accused person, Ieng Thirit, and her custodian, Ieng Wichada, Mr. Pat Persiang, and Counsel Diana Ellis are present. On the civil party side, we see Mr. Pick Ong and Mrs. Elizabeth Simonoho. Thank you, Mr. President. The President. In order to assist the accused person during today's session, 2 security personnel are assigned to assist her during the whole course of proceedings. On the 13th of September 2012, trial chamber of the ECCC issued a new decision in which Ieng Thirit is found to be unfit to stand trial, and that the proceedings are stayed indefinitely, and that accused person Ieng Thirit is ordered to be released immediately, and that the accused person is reminded of some conditions pursuant to Internal Rule 35 of the ECCC Internal Rules. The appeal. This decision was appealed by the co-prosecutors, and that the co-prosecutors on the 14th of September 2012 filed their appeal to delay the release of Mrs. Ieng Thirit. And then the Supreme Court chamber issued a decision rejecting such application and ordered that Ieng Thirit be released on the 16th of September 2012. The co-counsels for Ieng Thirit filed their application asking for immediate release of Mrs. Ieng Thirit without any condition, and that the co-prosecutors also submitted additional submission on the 28th of September 2012 when the co-counsels then replied on the 18th of October 2012. I would like now to proceed to inform the accused person of her rights. According to Internal Rule 21, subparagraph 1d, Every person suspected or prosecuted shall be presumed innocent as long as his or her guilt has not been established. I would like now to ask the court rapporteur to read the report of the proceeding, the report of the examination, rather. Co-rapporteur, report of the co-prosecutor, of the co-rapporteur pursuant to Internal Rules 108, subparagraph 5. Having been appointed by the President of the Supreme Court Chamber to act as co-rapporteurs for the appeal, we hereby submit our report setting out the details of the trial chamber's decision on reassessment of accused Ieng Thirit's fitness to stand trial following Supreme Court Chamber decision of the 13th of December 2011, which is appealed against, and the relevant facts of the case. A. Trial chamber's decision. The impugned decision reaffirmed that Ieng Thirit remains unfit to stand trial after additional treatments recommended by experts have been administered to her. Given that there is no reasonable prospect for the accused to regain competency in the foreseeable future, the trial chamber ordered an indefinite stay of proceedings. It concluded that its jurisdiction over the accused is suspended, though it lacks a clear legal basis to impose coercive conditions or other forms of judicial supervision over the accused upon release. The trial chamber therefore ordered the unconditional release of the accused. B. Appointment of a guardian. 2. On 15th of September 2012, the Phnom Penh Municipal Court appointed Ieng Wichida, the accused's daughter, as general guardian. C. Appeal by the co-prosecutors. The co-prosecutors argued that the trial chamber erred by suspending its jurisdiction over the accused and that her release should be subject to conditions of judicial supervision. Specifically, they request that this chamber impose 6 conditions: that the accused should 1. Reside at a specified home address provided by her co-lawyers. 2. Make herself available for a weekly safety check by authorities or officials designated by the trial chamber. 3. Surrender her passport and identification card. 4. Refrain from directly or indirectly contacting the other co-accused, excluding her husband, Ieng Sari, and any witness experts or victims who will be heard by the trial chamber. 5. Not interfere with the administration of justice. And 6. Undergo semi-annual medical examinations by practitioners appointed by the trial chamber. D. Defense response. The defense argues that the imposition of judicial supervision and coercive conditions has no legal justification and serves no rational purpose given the indefinite stay of proceedings, the absence of a reasonable prospect of the accused being tried, or her inability to remember, comprehend, or abide by any coercive conditions imposed on her. Further, the defense contends that the appointment of a general guardian to the accused will not assist in the enforcement of coercive conditions, as this would fall outside her role under Cambodian civil law. Phnom Penh, 12 of November 2012. Judge Samsaravut, and Judge Aniska Klinovika-Milad. The President thanks you, Judge co-rapporteur. We would like now to proceed to the co-prosecutor. Co-prosecutor. Thank you, Mr. President, and Your Honors. Today, on behalf of the prosecution, I am on my feet to submit our submission on the appeal against the decision of the trial chamber. The President, co-prosecutor, please speak louder because you are hardly heard. Co-prosecutor.
May it please you, Mr. President, I apologise for interrupting the co-prosecutor, but we had understood that the matters this morning would commence with any questions which were to be asked of Madame Yang Tirit. I raise this because, having spoken with her daughter this morning, we understand that it is very difficult for her to maintain a position where she's seated for any significant length of time. Indeed, we were advised that it would be difficult for more than a few minutes. In those circumstances, we had understood she was to be questioned if Your Honours wished to question her before submissions were heard. I raise that out of concern for your being able to achieve what your aim is, if that is possible, when she is most able, if she can, to answer.
The President, I would like to also know whether accused person Yang Tirit can remain seated for a few more minutes or not. Could you ask her for us, please?
The President. Counsel, can you please report back to us?
Mr. President, I'm sorry for what has taken place. The difficulty we have is that it's very difficult for Madame Yang Tirit to understand what she's being asked, which is why this morning I spoke with Yang Vishida to inquire as to the facilities which would be necessary to accommodate the respondent. And I was then told, and I'm not hearing anything to the contrary, that she will not be able to sit for very long. She has physical problems if she sits in this position and needs to lie down. She's also had very little, if any, sleep. It was for that reason that we thought Your Honours would best achieve any aim you had if she was spoken to at an earlier rather than later stage.
The President, in order to facilitate the accused due to her health condition, I would like to instruct the security guards to bring the accused down to the holding cell downstairs, where the facility is arranged for her. Do you have any objection or remarks concerning sending her back to the holding cell downstairs?
Not at all.
We do understand that facility was made available to the accused so that she could lie down or be at a comfortable environment while watching what is going on in the courtroom. She's not under detention. The holding cell is used solely for the purpose of her convenience, and the accused is not under guard there.
Your Honour, may we say that we are grateful for the facilities. We see it at the moment as a holding room and not a cell.
Thank you.
The President. So I now hand over to the prosecution to resume their submission. Co-prosecutor, thank you, Mr. President, and thank you, Your Honors, and good morning to everyone. Today, the Office of Co-prosecutors will submit the oral submission in relation to the decision on the unconditional release of Ieng Thierry. Your Honors, you have directed us to make submissions on the third and fourth grounds of the co-prosecutor's appeal against the trial chamber's decision on the 13th of September 2012. I will make my submission in three parts. First, I will refer very briefly to the trial chamber's factual findings, which have an impact on the issues which are before you. Second, I will make submissions on our third point of appeal, namely the trial chamber's refusal of the 6 restrictive conditions on Ieng Thierry's release. And third, I will address our fourth ground of appeal, the trial chamber's findings that the restrictive conditions would be unenforceable or impractical. At paragraph 24 of its decision, the trial chamber sets out its findings as to the effect of Ieng Thirit's cognitive impairment. In summary, the chamber found that Ieng Thirit suffers from a dementing illness, most likely Alzheimer's disease. This illness has caused a long-term and short-term memory loss, which prevents Ieng Thirit from understanding the course of the proceedings in a manner sufficient to adequately instruct her counsel and to effectively participate in her own defense. The chamber has also noted that it appears unlikely that Ieng Thirit would be able to testify at trial. The co-prosecutors and the defense do not take issue with these findings. What emerges from these findings, however, is that Ieng Thirit has not lost all cognitive abilities. While her memory is diminished, the chamber did not find that Ieng Thirit is unable, for example, to communicate with those around her or understand instructions given to her. As I will demonstrate later, this is relevant to the issue of enforceability and practical application of the proposed restrictive measures. On the issue of prospects for improvement, the Chamber's finding is also qualified. At paragraph 24, the Chamber found that there appears to be no reasonable prospect that Ieng Thirit's cognitive impairment can be reversed. In other words, the possibility of reversal cannot be excluded conclusively. This is reflected in the trial chamber's allowance for the possibility of a presumption of the resumption of the proceedings. At paragraph 28, the chamber orders the proceedings against Ieng Thirit stayed until and unless the chamber orders their resumption against the accused. The chamber further states at paragraph 39 that it is willing to consult annually with the experts to ascertain whether new treatments for progressive dementing illness, in particular Alzheimer's disease, have in the interim been improved. These parts of the trial chamber's decision are important in our submission as they clearly reflect the chamber's acceptance of the submission we made on the 31st of August 2012, namely that while a change of circumstances in relation to Ieng Thirit remains unlikely, it cannot be entirely dismissed. In sum, the present position is that while Ieng Thirit does not face a reasonable prospect of a trial in the foreseeable future, she retains some cognitive capacities and the possibility of her recovery, and a resumption of the trial, while remote, cannot be conclusively excluded. Against this background, I will now deal with the two grounds of appeal that you have asked us to address. As your honors would recall, in our first ground of appeal, we submitted that under the applicable international jurisprudence, having ordered a reversible stay of proceedings, the trial chamber was required to consider whether any restrictive measures should be placed on Ieng Thirit's release. Our third ground of appeal builds on this point. We submit that the trial chamber was obliged to assess and balance the rights and interests at stake in deciding whether any condition would be appropriate. The trial chamber erred by declining to undertake this balancing exercise and finding instead that it had no legal basis to impose restrictive measures. This decision was based in part on what is in our submission as an incorrect reading of the applicable international case law. I will deal with three relevant cases which the trial chamber has considered. The ICTY decision in Talik and Jukik, and the decision of the East Timor Special Panels for Serious Crimes in the case of Nahak. The trial chamber has sought to distinguish these cases from the case of Ieng Thirit. We respectfully disagree and submit that the principles emerging from these cases should have guided the trial chamber's approach in this case. Talik and Jukik were both terminally ill. Both were released while the proceedings against them were stayed. At the time of their release, both accused had no prospects of recovery. And yet, in both cases, fully cognizant of the fact that a resumption of trial against these accused were extremely remote, the ICTY did not release them unconditionally, but imposed a set of restrictions on the accused. The ECCC trial chamber distinguishes Talik on the basis that, in that case, there was disagreement between the experts as to whether the accused was fit to stand trial. Firstly, the difference between the experts in Talik related only to the accused's fitness in the short term. Secondly, that difference of opinion is irrelevant because fitness to stand trial is determined by the court, not the experts. Thirdly, and most importantly, all three experts accepted that Talik was suffering from an incurable form of cancer and that his death within a relatively short period of time was inevitable. The ICTY trial chamber echoes this in paragraph 32 of its decision of the 20th of September 2002, and I quote, "The stark reality of Talik's medical condition is that there is no escape for him from the natural consequence that his illness will ultimately bring about because his condition is incurable and inoperable and can only deteriorate with or without treatment. The stark reality is that the odds in favor of his being alive a year from now are few indeed." End quote. As another basis to distinguish Talik from the case of Ieng Thirit, the ECCC trial chamber states that in Talik, the ICTY declined to make a final determination on fitness. In fact, there was no refusal to rule on fitness because there was no application before the chamber to determine fitness. A determination of fitness was not necessary given the accused's condition. He was suffering from a rapidly developing terminal illness with an extremely short life expectancy. The ECCC trial chamber further seeks to distinguish Talik on the basis that the condition on his release were justified by the possibility that he may eventually stand trial. At paragraph 62 of their appeal response, our learned friends counsel for Ieng Thirit raised a similar point. They argue that Talik is to be distinguished because of the reference in the ICTY decision to his trial being ongoing. We submit that this is not a correct reading of the decision. The reference to a possible resumption of proceedings and ongoing trial in Talik should be understood in light of the following facts. Talik was indicted together with another accused, Bjanin. By September 2002, their trial was in progress, but Talik was diagnosed with terminal cancer and a decision was made on provisionally release him. By a separate decision issued on the same day, on the 20th of September 2002, the ICTY trial chamber severed the case against his co-accused Bjanin so that the second case could continue. Talik's trial was stayed and never resumed. At the time of issuance of this decision, Talik's chances of resuming trial were more remote than those for Ieng Thirit. Talik, in fact, died within 9 months of being released. Your Honours, we submit that all of these purported distinctions between Talik and the case of Ieng Thirit are ultimately artificial and unconvincing. All cases must be decided on their own merits, but the principles arising from Talik should not be ignored. Talik's trial could not continue and were suspended indefinitely. Prospects of a resumption of that trial were extremely remote. And yet, the ICTY considered that it was appropriate to put in place a range of measures to safeguard the integrity of the proceedings. You are facing a similar situation, Your Honours. An accused is being released with no immediate prospect of a resumption of her trial, while the trial against her co-accused is continuing. Unlike Talik, Intirit is not terminally ill. In fact, the evidence we have heard in court indicates that her physical health is very good for a person of her age. Therefore, while she faces a remote prospect of a resumption of trial, that prospect is higher than the prospect in Talik. And finally, Intirit is charged with crimes whose gravity far exceeds the gravity of the crimes with which Talik was charged. The case of Jukik is also relevant. As I indicated earlier, the facts of this case were similar to those of Talik. During the pre-trial proceedings, the accused was diagnosed with a terminal illness in an advanced stage. A recovery was ruled out. In fact, he died within less than a month of his release. And yet, the ICTY trial chamber considered it necessary to impose a set of restrictive measures on his release. In distinguishing that decision from the present case, the ECCC trial chamber simply noted that Jukik was described in Talik as a practically unconditional release. In our submission, this is irrelevant. Jukik were subjected to more modest conditions than those applied in Talik. But this is simply a reflection of the fact that each case turns on its own circumstances. The indisputable fact is that Jukik's release was subject to conditions which the chamber in that case described as stringent. And the third precedent, which the trial chamber declined to follow, is the 1st March 2005 decision of the East Timor Special Panels for Serious Crime in the case of Nahak. In that case, the accused was found unfit to stand trial due to a long-standing psychiatric condition. His trial was stayed, and he was ordered to remain under a set of restrictive conditions. The ECCC trial chamber states that no legal justification was given for his order. We submit that this is an incorrect reading of the decision. The judge in Nahak made it clear that the basis for a continuation of the restrictive measures against the accused was the remote possibility of a resumption of trial. This can be found at paragraphs 157 through 164 of that decision. Furthermore, in a manner similar to that which we have proposed before the trial chamber, the judge in Nahak provided for either the prosecution or the defense to apply for a variation of the restrictive measures should there be a change in the circumstances. Your Honors, while in this area of the law jurisprudence is necessarily limited, one must look at the substance of the available cases and consider what guidance they provide. In our submission, these decisions are a clear authority for the principle that in cases of serious international crime, where a reversible stay of proceedings has been ordered, even where a resumption of the trial is remote, it is appropriate to consider the imposition of the restrictive measures on an accused who is being released. What measures are appropriate will, of course, turn on the facts of each case. In some cases, the measures will be extensive, such as in Talik. In others, they will be limited, such as in Jukik and Nahak. But it cannot be said that once a stay has been ordered, the trial chamber lacks jurisdiction to consider any restrictive orders.
Of course, the international case law mandates that any measures restricting the rights or liberties of individuals must be proportionate to the aim sought to be achieved. In the Talik decision, the ICTY held at paragraph 23 that to be proportionate, a measure must be suitable and necessary. Furthermore, the degree and scope of the measure must remain in a reasonable relationship to the envisaged target. It is our submission that the 6 modest restrictive measures we have proposed meet these criteria. First, if I can deal with the aims sought to be achieved by the restrictive measures. On the one hand, from the trial chamber's decision, it appears that the chamber considered that the only aim to be safeguarded is the accused's attendance at trial. This is implicit in the chamber's reasoning that no measures can be imposed on an accused where there is no reasonable prospect that the accused will be tried in the foreseeable future. Paragraph 33. This would, of course, be an unduly narrow reading of the law, especially in light of Internal Rule 63(3)(b), which provides for a whole range of interests which can form the basis of a detention order. And yet, by putting in place a set of unforeseeable measures framed as requests to the accused, the trial chamber seems to be seeking to protect a broader range of interests. In addition to requesting the accused to remain in the territory of Kingdom of Cambodia and inform the ECCC of any change of address, the trial chamber reminds the accused of her obligation not to interfere with the administration of justice and requests her not to communicate with the media in relation to these proceedings. These requests facilitate the achievement of the same aims which the co-prosecutors' proposed measures were designed to achieve, namely, protecting witnesses and victims, protecting the security of the accused, preserving public order, and, of course, ensuring the presence of the accused at any future hearings. The trial chamber obviously recognized the need to protect these interests by putting in place the unforeseeable measures I referred to earlier. I note that at paragraph 61 of the appeal response, Counsel for Ieng Theron recognized that considerations such as the need to protect victims and witnesses may form the basis of judicial supervision order. Your Honors, we have submitted that the trial chamber has the power to protect these interests by way of enforceable orders, and that issuing requests to the accused which have no legal force is not the appropriate course of action. The enforceable measures we have sought represent a minimal interference with the accused's rights to liberty. There is no proposal to place her under house arrest. No particular address is being prescribed at which the accused would have to reside. Her movements, as long as she remains within the country, are essentially unimpeded. The weekly security checks are not onerous and could be arranged in a manner that minimizes disruptions to the accused's freedom of movement. The requirement not to contact other co-accused, except husband, as well as victims and witnesses, is a reasonable measure that is necessary to safeguard against potential interference with the proceedings. We would respectfully remind the court that up until her release, the accused was held in detention in order to safeguard against these various risks. The proposed requirement that Ieng Thurit undergo regular medical examinations is not dissimilar from the trial chamber's own provision for annual consultation with medical experts. Your Honours, we submit that the imposition of these measures strikes a reasonable balance between, on the one hand, protecting the rights and interests of the victims and co-prosecutors to see justice done, and, on the other hand, the need to minimize the restrictions on Ieng Thurit's freedom of liberty. As we stated at the hearing on August the 31st, we do not propose that these measures continue indefinitely. We recognize that a point in time may come at which the measures may need to be discontinued. 6-monthly reviews and, in any event, a review at the conclusion of case 002/01 would ensure that Ieng Thurit is not placed in a state of uncertainty. And the final issue you have asked us to address today is the implementation of the proposed measures. At paragraph 37, the trial chamber questions the practical or legal enforceability of these measures. The chamber doubts whether the accused would be capable of forming an intention to violate the conditions or that penalties could be imposed on her in the event of a breach. We respectfully submit that the chamber has committed a discernible error of discretion in its approach to this issue. Whether the accused could ultimately be penalized for a breach of a court order is not determinative of whether the order should be imposed in the first place. The purpose of issuing the orders is first and foremost to protect the interests which the chamber has recognized require protection. A court order addressed to the accused sends an important message about the behavior which she must refrain from. As I indicated earlier, the trial chamber did not find Ieng Thurit to lack any cognitive capacity. There is no reason to believe at this point that Ieng Thurit would be unable to comply with the orders. In any event, she would be assisted in this respect by her guardian, who has now been validly appointed by the municipal court. It would only be upon any breach by Ieng Thirith of the conditions of her release that the court would need to consider consequences that would follow for the accused. While one avenue of dealing with such a breach is provided in Rule 35, which requires a willful and intentional act, a breach could also be dealt with by reviewing and strengthening the restrictive conditions themselves. In any event, by deciding not to impose any conditions now, because there may be obstacles in imposing penalties for their breach, the trial chamber has improperly fettered its discretion in this matter. Turning to the issue of the role of the guardian, we note that guardianship applications were filed on the 13th of September by both the municipal prosecutor of Phnom Penh and Madam Ieng Vichada, Ieng Thirith's daughter. In her application, Madam Vichada sought to take care of her mother at her own residence and agreed to be subject to any orders the court may impose. Our learned friends counsel for Ieng Thirith argue that we have sought to circumvent the jurisdiction of this court by pursuing the imposition of coercive conditions through the guardianship procedure. And I can deal with this issue in very brief terms. First, to state the obvious, the ECCC Office of the Co-Prosecutors is a body entirely separate from the Phnom Penh Municipal Prosecutor's Office. Secondly, Madam Vichada herself sought to be appointed as a guardian to her mother. She is a well-educated individual who is perfectly capable of exercising her rights in an informed manner. She has agreed to any conditions to be imposed by the municipal court. Thirdly, it is our understanding that Ieng Thirith's defense counsel was consulted in this process. Therefore, would be disingenuous to suggest that actions were taken by the Phnom Penh prosecutor without the knowledge of Ieng Thirith's counsel. Your Honours, there can be no suggestion of an improper attempt by this office to have coercive measures imposed by another judicial institution. As soon as we read the terms of the trial chamber's decision, we filed an immediate appeal before the Supreme Court chamber. We have no standing before the domestic courts, nor would we seek to frustrate our own appeal by pursuing proceedings in other judicial institutions. Incidentally, we note that our learned friends have asked you to remove the measures imposed by the municipal court as part of the decision on the appointment of a guardian. That order would, of course, be beyond this court's jurisdiction. As the pretrial chamber noted in its 3rd of December 2007 decision on Dutch appeal against a provisional detention order, the ECCC has no power to review decisions of regular Cambodian courts. Should Ieng Thirith or her guardian take issue with the terms of the municipal court decision, a number of options are available to them. They have the option of seeking a variation of the guardianship decision under Articles 39 to 42 of Law on Procedure of Non-Suit Civil Case. They were also entitled to an appeal before the appeals court against the decision within 2 weeks of the service of their decision. In its disposition, the municipal court specifically reserved that appeal right. We are not aware of any appeal having been filed. Furthermore, under Articles 1105 and 1110 of the Civil Code, the current General Guardian can also apply for the appointment of an additional guardian or assist with the implementation of the guardianship if she considers that necessary. Our learned friends, the Council for Internet, also submit at paragraph 79 of their appeal responses that the prospect of sanctioning a guardian of a respondent for a lack of compliance imposed on the respondent is without legal basis. We consider these submissions to be superfluous. The guardian has a duty to assist the accused in complying with her legal obligations, provided the guardian has discharged their duty, and of course, no sanctions would be imposed on her for a failure by Internet to comply with court orders. The purpose of a guardianship is to assist the beneficiary in exercising her rights and obligations, not to create an alternative for enforcement of sanctions. Finally, it is our submission that the appointment of the guardian will facilitate the implementation of the proposed measures, just as the guardian would assist Internet in discharging her rights and obligations in general. She would also assist Internet in complying with any restrictive measure imposed by the court, and the guardianship creates a contact point through which the court can communicate with Internet. It also ensures that the instruction can be given to Internet's counsel in the event that Internet herself is unable to do so. We note that the submissions issued to Internet in respect of these hearings were signed by Vichada and her guardian, and here today we see that Internet has complied with your summons, and Madam Vichada has attended the hearing in order to assist your honors. This is perhaps best illustration of her way in which the guardianship can operate effectively to facilitate implementation of the measures we have proposed. In conclusion, your honors, we have recognized that based on the evidence currently available, the possibility of resumption of the trial against Internet is remote. But that possibility cannot be excluded. For as long as the stay of proceeding is reversible, the court has jurisdiction to issue such orders as may be necessary to safeguard the integrity of its proceedings. Those orders include measures to restrict the accused's liberty in a manner that is reasonable and proportionate. In a case of this magnitude, where the accused is charged with some of the worst crimes known to humanity, which affected literally millions of people, there is a compelling public interest in maintaining judicial control over the accused until it becomes absolutely clear that no trial against her will ever take place. It is also appropriate to maintain that judicial control in order to provide certainty for the accused. We submit that the trial chamber has erred by concluding that it had no jurisdiction to consider or impose restrictive measures, and by failing to weigh Internet's right to liberty against all of the other rights and interests which are affected by the chamber's decision. We submit that the very limited conditions we have proposed will effectively safeguard the rights and interests of victims and the integrity of these proceedings, while minimally restricting Internet's right to liberty. We invite your honors to amend the trial chamber's decision by imposing the conditions sought by the co-prosecutors on the 31st of August 2012. We thank you so much indeed, your honors. The President, International Co-Prosecutor, would you wish to add something else on top of this? You may have the floor.
No, I thank Your Honours. Those were our joint submissions. We're available to answer any further questions Your Honours might have, but those are our submissions for now. I thank you, and I thank you for the extra time.
The President, next we would like to hand over to counsels for the accused person to make their submission. Counsel Pat Pai Siang. Very good morning, Your Honors. Very good morning, Mr. President, and very good morning to everyone in the courtroom. For our oral submissions, we would like to submit it into two sections. First, I will be making the submission, and the second part will be shared by my colleague, Counsel Diana Ellis. Allow me, Your Honors, to make this oral submission in response to the oral submissions by the co-prosecutors as follows. The respondent requests Your Honors to reject the appellant's immediate appeal against the trial chamber's decision on reassessment of accused Ieng Therit's fitness to stand trial following the Supreme Court chamber decision of the 13th of September 2011 and their supplementary submissions in their entirety. And uphold the trial chamber's impugned decision. Further, the respondent requests the removal of the coercive conditions which were attached to the respondent's release while she waited the hearing of the appeal. The respondent submits that the trial chamber did not make any error in law or fact, occasioning a miscarriage of justice or in the exercise of its discretion which resulted in prejudice to the appellants. Accordingly, the trial chamber was correct to order the immediate unconditional release of the respondent. It is unnecessary to restate in detail the arguments set out in the response to the co-prosecutor's immediate appeal and supplementary submissions filed on the 8th of October 2012. The legal principles and the framework which are relevant to the liberty of an accused are fully set out in the response. We submit that even though judicial supervision is less draconian than pretrial detention, it necessarily imposes restrictions on the right to liberty of an individual and therefore should only apply where it is ordered on a sound legal basis. Further, it is respectfully submitted that the ECCC chambers should act in accordance with the well-recognized principles designed to ensure that the respondent is not subject to arbitrary deprivation or limitation of her right to liberty without good and proper cause justified by the applicable law. The relevant provisions in the case at hand are Internal Rules 63, 65, and 82, Articles 223 and 230 of the Cambodian Code of Criminal Procedure. The respondent is permanently unfit to stand trial. The respondent suffers from moderate to severe dementia, probably Alzheimer's disease, which was diagnosed in 2011 but been developing over several years. The court-appointed medical experts have unanimously concluded that there has been no improvement of her condition since Your Honours directed that she should undergo further treatment. But they found signs of further deterioration. The sad reality is that the respondent's condition is such that her cognitive functioning will deteriorate over time. She is not fit to stand trial and will never become fit to stand trial. There is no evidential basis upon which this court can conclude that the respondent will ever become fit to stand trial. In recognition of this fact, the trial chamber stayed the proceedings indefinitely and confirmed the 2011 decision to sever the charges against the respondent from case 002/01. The appellants implicitly accepted that the respondent will never be fit to stand trial when they stated that the impugned decision satisfies the provisions of Internal Rule 104, subparagraph 4a, as a decision which has the effect of terminating the proceedings. They also explicitly stated that it is unlikely that the respondent will face a trial in the foreseeable future in the course of argument in August 2012. The respondent supports this assertion as, in effect, there is a termination of proceedings, although there is no legal mechanism available for formally terminating proceedings in case of unfitness to stand trial. Within this jurisdiction, unlike in many common law jurisdictions, it follows that measures which impose restrictions on the liberty of the respondent have no justifiable legal basis and authority. Pursuant to the provisions of Internal Rules 65, subparagraph 1, conditions may be imposed following the release on bail of a charged person when such conditions are necessary to ensure the presence of the person during the proceedings and the protection of others. Thus, it is not mandatory to impose conditions. Measures taken at the investigating stage of the proceedings must be the ones least intrusive to the charged person. This principle is related to the presumption of innocence. As a result, a tribunal should favor release at the earliest reasonable opportunity and with the least intrusive conditions necessary to satisfy the requirements of Internal Rule 63. The requirement of necessity cannot be deemed fulfilled in the present case, taking into account the circumstances. The trial chamber rightly held that If there is no legal basis for continued detention of the respondent based on its finding that there is no reasonable possibility that she will become fit to stand trial in the foreseeable future. By analogy, there is no legal basis for the imposition of coercive conditions or any form of judicial supervision upon the respondent's release. Because there is no prospect of a trial being held ever, imposing these 6 conditions would amount to a restriction of the respondent's rights to liberty not provided by law. Internal Rule 65, subparagraph 1 provides for 2 cumulative justifications for imposing judicial supervision. 1. To ensure the presence of the charged person at trial, and 2. For the protection of others. Article 223 of the Cambodian Code of Criminal Procedure also presupposes that there is a reasonable prospect of an ongoing trial. In Talich, the trial chamber held that in determining these individual cases requesting provisional release, it is necessary to bear in mind the rationale for the institution of provisional release, which is linked to the rationale for the institution of detention on remand. Accordingly, imposing conditions presupposes that there will be a trial and the existence of a real risk that the accused is going to fail to attend the trial and or that others need protection. Given the factual determination of the proceedings, these 2 cumulative requirements are not met. The appellant's contention that imposing judicial supervision on the respondent is necessary to safeguard the integrity of the proceedings and to serve legitimate public purposes should be rejected as having no legal basis. It is contrary to the respondent's right to be tried within reasonable time, to be placed under judicial supervision for an indefinite period of inactivity in a case where there is no prospect of a trial. Your Honours, my colleague will now address the 6 coercive conditions proposed by the appellants more specifically.
May it please Your Honours, could I firstly correct a point made by the appellants? It is our submission that there should be no conditions imposed upon the respondent, and that those conditions which were imposed by this court when her release was ordered should also be lifted. We did not, in our response, at any time suggest that this court had the jurisdiction to interfere with any order made by the Municipal Court of Phnom Penh, and we do not advance any such argument before Your Honours. I would like to specifically address the request of the appellants as set out in the immediate appeal dated the 14th of September of this year, paragraph 2, namely that the respondent be required through any duly appointed guardian to comply with specific conditions to appropriately safeguard the competing rights and legal interests engaged by her release from detention. That involves looking at three separate elements: the conditions that are proposed, the reasons put forward to justify them, and the manner in which it is suggested the respondent complies with such conditions. In other words, how they are implemented and enforced, to quote the appellant. Before touching on those three separate matters, it is important to remind the court respectfully of why it is we are here today. It is because the respondent, aged 80, is mentally incapacitated, and it is with that in the forefront of your minds that focus must be made on these points. It is the unanimous view of all the experts, independent, international and Cambodian, court-appointed in every case, that the respondent is suffering from dementia. Your Honours will have, of course, seen all of the reports which now span a considerable period of time, which describe her condition, which rely not only on the assessments of the doctors, but standardized tests, the views of those who've observed her behavior. They are all of one voice. The condition is incurable, irreversible, and the prognosis is one of increasing incapacity. It is a genuine condition, not faked. It is a tribute to this court that Your Honour's decision of December the 13th of last year led to a programme of medication and cognitive therapy in the hope that this might in some way alleviate the condition. Regrettably, it did not. And indeed, as the doctors noted in August of this year, there was a further deterioration, as is normal with this particular condition. Most significantly, no memory, short-term or long-term. It is completely wrong of the appellants to say that there is evidence before this court that the respondent could communicate intelligibly with anyone. The evidence, on the contrary, was that she didn't recognise her nearest and dearest. She didn't remember individuals from 1 hour to the next. She couldn't orientate herself. She couldn't focus, and she couldn't respond to questions. And that was the reality. There is no mechanism within the jurisprudence of this court to acknowledge when an individual becomes unfit to stand trial in a way that allows the proceedings to be terminated. Clearly set out in the codes are the circumstances that allow that. There is no reference to mental incapacity, and it is, we submit, for that reason that the trial chamber has been forced into a position of relying on the mechanism whereby it could stay the proceedings for an indefinite period. But we submit that it is a complete fantasy for this court, or indeed anyone, to imagine for 1 minute that there is going to be any improvement in the mental health of the respondent such that will allow her to stand trial. We heard the evidence in the lower court that there are no treatments that can improve this condition for more than a matter of a few months before the downhill progress continues. The drug companies have stopped funding this research on dementia because it has had so little success. There possibly will be, in many years to come, ways of treating dementia. But of course, before they're within the public domain, they're subject to trials. And therefore, to look at the respondent in her 81st year and to suggest sensibly for 1 minute that she might become fit to engage in the trial process is, we submit, a complete fallacy. And it is against this background that you have to look at the conditions that it is sought to impose upon her under judicial supervision. We would submit that the appellants fully understand that there will be no trial because it formed part of their justification for appealing that the result of the trial chamber's findings, and they never contested the fitness, was that effectively there would be a termination. If that is the effective position, which we submit it must be, then if we move on to look at the actual conditions that they request, conditions which they describe themselves as restrictive and coercive, and which have been read out, and I will not repeat, but are set out at paragraph 10 of their immediate appeal on the 14th of September. These amount to the kind of conditions that are imposed in order to check and control the movements of an individual and to ensure there is no interference with the administration of justice. They are conditions which clearly can be imposed through Article 223 of the Cambodian Code of Criminal Procedure. Likewise, the internal rules of the ECCC permit, under Internal Rule 65, bail conditions which could include any or all of these specifically set out conditions. What is the objective that the appellants seek to achieve? They have developed their arguments in their supplementary submissions set out in their document of the 28th of September of this year. At paragraph 5, they accept that primarily they are securing, if they can, the attendance of the respondent were there to be a future trial in respect of the notification as to her whereabouts. They wish, they say, to preserve the integrity of the proceedings. They wish to protect others. They wish to prevent pressure being put upon witnesses or victims or any other person who might be an anticipated witness. They wish to protect the respondent. They wish to preserve public order. Of course, all of these objectives, in fact, are to be found in Internal Rule 63.3 at the point at which it is determined that the individual, the charged person, or the accused, is to be held in preventive detention. And that is why, as you've heard in the argument of my colleague, we submit the truth and the reality behind these objectives is to ensure the attendance of the respondent at a future trial and to ensure there is no disruption with the administrative process, the proceedings. Worthy objectives, of course, but there is no evidence that the respondent needs protection from others. She has now lived with her family for a significant period of time without any problems arising. There is no evidence of any pressure put upon anyone who has an interest in these proceedings, nor any attempt to contact any of the co-accused, other, of course, than her husband, which is permitted. And there is no evidence of any concern at this stage to preserve public order. The public, if we may comment, dealt with the decision of the trial chamber to order the unconditional release in a very understanding and sophisticated way, no doubt appreciating the basis upon which that decision was taken. The court has to have clear evidence, and that is apparent from international jurisprudence, if it is to seek to fulfill the objectives that I have just referred to. And of course, the primary objective, by virtue of the notification of the address that is sought, is in order to, we submit, unrealistically suggest there might in the future be a trial. The appellants have sought to invoke the inherent jurisdiction of the court in order to impose conditions which, to quote them, are to ensure a good and fair administration of justice. Of course, no condition is necessary for that. All citizens within this country, as everywhere, are obliged to ensure there is no interference with the administration of justice. And should there be, deliberately and intentionally, then the perpetrator is subject to the criminal offence if appropriate. We submit that the appellants have sought to rely on the inherent power in the realisation that under the internal rules of this court, which of course reflect very much the content of the Cambodian Criminal Code and indeed the French Criminal Code, these conditions sought do in fact anticipate attendance at a trial and that there should be no interference in advance of that trial. We submit that it is entirely erroneous of the appellants to characterise the situation that faces your honours as being a balancing exercise of all the interests at stake. This is not a balancing exercise. This is a situation in which an accused, the respondent, is no longer able to participate in trial proceedings through no fault of her own. What follows from that is that were there to be conditions imposed upon her, it would have to be shown in the event of any breach that that breach had been intentional, that she had intentionally evaded an obligation of judicial supervision, in which circumstances, according to Article 230 of the Cambodian Code of Criminal Procedure, a judge can order preventive detention. Because, of course, an intentional breach gives rise in any criminal justice system to an appropriate sanction. It is entirely repugnant to a system of justice for there to be the imposition of conditions which can never be met through no fault of the individual concerned, and which can then, if breached, be met by sanctions. And of course, we're confident that would not happen. But a court is brought into disrepute if, in the face of evidence that the respondent cannot know what is meant by the conditions, cannot know how to comply or not, but nevertheless inadvertently might wander the streets and end up somewhere else, for example, and then be sanctioned for what she's done, that would be a wholly unacceptable, inhumane state of affairs, and one which we're confident would not arise. And no court should be in a position where it puts in place coercive measures which it is clear on all the evidence cannot be complied with. It makes a mockery of the whole system. The position of the respondent at this time is that she remains, in spite of the gravity of the offences with which she is charged, presumed innocent. That is her right. She also has a right to liberty. That right should only be displaced when there is proper reason for it. It is clear from the internal rules that however grave the crime, the position is not, as perhaps implied by the appellant, that it is appropriate, therefore, to have conditions, because the rules envisage provisional detention where deemed necessary in accordance with Internal Rule 63, bail in accordance with Internal Rule 65 where it's not necessary to detain, but also unconditional release where that is appropriate. If the court saw fit to impose conditions and felt the objectives were justified, then it is necessary to consider whether compliance can be obtained. If compliance, for the reasons we've already submitted, are due to mental incapacity, cannot be placed upon the shoulders as the responsibility of the respondent, can it fall to the guardian? We submit that just as the municipal court in Phnom Penh is a separate jurisdiction, this court has no jurisdiction over the guardian. A guardian cannot take upon herself the responsibility to ensure compliance. The rules indicate that it is not a third party who has to ensure compliance, but it is the individual upon whom the conditions are made who must be able to comply. We would like to make short comments about the guardianship order. A guardian has the legal authority to care for the personal and property interests of another person who is in need of protection. The appointment is made because the individual, the ward, is incapable of caring for her own interests due to incapacity, disability, or infancy. That is the definition of a guardian. It is a protective function. It is not in any way to be the person who ensures coercive measures are complied with. That is a complete contradiction of the role. The general guardianship order, which was imposed, allows Yang Vishida to look after her mother, and it is a measure put in place to protect the respondent due to her incapacity. Under Article 24 of the Code of Civil Procedure, an order can only be made where a person remains in a habitual condition, and I underline habitual, condition of lacking the ability to understand the legal consequences of her actions due to mental disability. It is under that article that the guardianship order has been made, and I know your honours have a copy of it. I want to correct the manner in which that order came to be made, because we submit it has been dealt with in an unfortunate and inappropriate way. The application was not made at the instigation of Madame Yang Vishida, the daughter of the respondent. The application was made following the approach of the Deputy Prosecutor of this court, Mr. Yet Chak Ria. He, wearing a different hat, is the prosecutor of the Municipal Court of Phnom Penh. And indeed, as the prosecutor, he is referred to as having made the application. We accept that he spoke with my colleague about this matter, but the fact is it was an application generated by the prosecutor, we submit, at a wholly inappropriate time, because the approach was made on the 10th of September. On the 13th of September, the trial chamber gave its decision, which was to say there should be unconditional release, and that very same day, the prosecutor, that is Deputy Prosecutor of this court, went to the Municipal Court and there provided the documents that led to the appointment of Vishida as guardian. The decision to appoint her was made on the basis that it was said by the prosecutor she is permanently lacking the ability to understand and judge the possible legal action to do with Yang Tirit with cognitive impairment. And so the prosecutor requests general guardianship consistent with the application of Yang Vishida. Yang Vishida's request went no further, as you can see from the document, than that she wanted to be able to care for her mother in her home. As a result, the order was that there would be guardianship and indeed that there would be notification to this court of the address. And we submit there has been a worrying confusion of positions and that the prosecutor should have complied with Article 22 of the Code of Civil Procedure and waited until the outcome of this appeal before suggesting any other matter was pursued which touches upon the issues this court is considering. However, we are confident that this court will independently evaluate the situation. But we submit that the fact that there is a guardian does not allow this court to use the guardian as a way of imposing conditions upon the respondent. This court would have to be satisfied that the respondent understood the nature of the conditions, the obligations put upon her by the conditions, and the consequences of her failure in some way to abide by them. We may be talking in hypothetical terms to the extent that the incapacity of the respondent is such that in reality she may not be able to fail to comply with any condition. But that is not a basis for imposing it. Your Honours, we submit, have to look at the important principles. And the principles are that what this court, lower court, found, that there is mental incapacity, has now been also the view of a different judge.
The President, Counsel, could you please hold on a little bit, because the DVD has run out and we may need to have a new one replaced. Please, hold on. The President, you may now proceed.
The appellants have referred, Your Honours, to 3 cases. We submit none of those cases, nor indeed any other international jurisprudence, has relevance to this particular situation. The reason for that is that the cases that have been relied upon and cited to you involve in 2 instances terminal illness, and in the third, psychiatric illness, which was a psychotic illness. And what distinguishes those cases from that of the respondent is that a terminal illness, by definition, will cause death, but there is uncertainty as to whether there will be remission, and if so, for how long. But the one thing that is clear is that coming out of the decisions in Deutsch and Talich is the fact that there is no suggestion that in those cases the accused lacked the capacity to understand, and that there was never deemed to be such a lack of capacity or such physical infirmity that no trial could take place. The situation with Nahak was, of course, different because it was psychotic illness, but again, psychotic illness is very different from dementia. And dementia, as you've seen from the reports, is an illness of progressive deterioration and decline. Psychotic illness is frequently amenable to treatment, and therefore that was what was proposed. And in fact, events intervened which caused the court to cease sitting, and therefore the outcome was never known. And we submit that there has been no case which is on all fours with this, and indeed it is clear from the jurisprudence that in matters to do with fitness to stand trial, each case turns on its own facts. They are fact-specific cases. And so finally, we submit that the important principle for this court, who is essentially making law in this area, is to be true to the rights of an accused, that is the presumption of innocence, to acknowledge the right to liberty, and to accept that whatever the gravity of the crime, there is something entirely unacceptable and indeed repugnant in a civilized society to impose coercive and restrictive conditions on an individual who has no capacity to understand what's being imposed upon her and no capacity to decide whether to abide by the conditions or not. And therefore, we submit that the decision of the trial chamber that there should be unconditional release should be upheld by your honours in this court. And unless I can assist with any other matters, those are our submissions. Thank you.
The President. Next, the Supreme Court chamber wishes to pose some questions to the accused person. Nonetheless, we would like to seek advice from counsels for the accused person whether Mrs. Ieng Tirut is or avails herself to be questioned by the bench at this time.
Mr. President, we did understand that the court wished to be in a position to ask questions of the respondent. It is for that reason that she came into court this morning. If she is in a position to return, then of course we will ensure that she does. As to how that the questioning will progress, that will be determined when questions are posed. We can't assist further than that. But I don't know whether the court proposes rising or whether she can just be brought up by her daughter and those who are attending her.
The President, security personnel are now instructed to bring the accused person into the courtroom now.
សូមបន្តទៅទៀតដោយ
The President, we may proceed due to the medical condition of the accused person, Mrs. Ieng Thirit. It took some time to bring her to the courtroom. During today's session, indeed, the bench is not putting questions concerning the subject matter of the appeal. Ieng Thirit is allowed to remain seated next to her daughter and guardian. And we note also that Mrs. Ieng Thirit is fatigued and weak. Mrs. Ieng Thirit can request to the chamber that she be excused from this courtroom, and she may remain in the holding cell for the remainder of the day if she wishes to do so. And the two security personnel who accompany her and who are assisting her will be ready to help her for the remainder of the day. The judges of the bench wish to put some questions to the accused person, to Madame Ieng Thirit. At the same time, she can be reminded that she can exercise her right not to respond to any questions if she wishes to do that. The first question I would like to pose to her is that to Mrs. Ieng Thirit, how are you feeling? Can you hear me? How are you? Response, I am fine. I am very well. Question, have you been feeling better since you've been released and be at home? Response, I have been better because the host receives me well, and I am well treated. I am well assisted because they know what kind of medicine I should take. They help me recover, and I feel better now. The President. Next, I would like to hand over to the fellow judges of the bench to put some questions to Mrs. Ieng Thirit.
Thank you, Mr. President. Mrs. Ieng Thirit, the court has to ensure that it can reach you and that you can come to court if need arises for you to come to court in future. So the first question to you is, are you prepared to come to court if you are requested to do so in future?
Response, yes.
Thank you. Do you? Yes.
Mrs. Ieng Thirit, I also thank you very much. And for a period I have been staying there, I have been ill, and I have been in the forest, but my illness still remains.
Thank you. Do you have a permanent address in Cambodia?
Response. Here at the new place, I am treated and I follow them to this location. And that's all I wish to tell you.
Thank you. Do you have family and friends abroad, outside Cambodia?
Response. It is just normal. I have some friends abroad. They are professors, mainly professors, or school teachers. And they are very nice people. They protect me, they think of me, and they are also respected by their neighbors because they never treated me as someone who have committed any wrongdoings. From my young age until the time I graduated at French schools, I had been very much loved by the French teachers.
Thank you. Do you see any occasion requiring you to go abroad, outside Cambodia?
Response. No, I don't. Because at home there are Cambodian people who are educated who could help me. For example, whatever I need, I just communicate this to them, then they could assist me. And indeed, I would like to make sure that I still speak my foreign language, because everyone agrees that they would like to help me to remember the language I have acquired, and they note that Cambodia is a small country with small population. So they are happy about what I have learned, and they are happy because what I've learned so far, I still remember it.
Thank you. The court is considering continuing to monitor your health. Are you at present undergoing treatment or medical tests?
Response. Currently, at the place where I stay, there is service, and they know my condition, so they remain there to assist me, to help make sure that I can deal with this, because sometimes after working too long hours, I do not wish to eat my meal, so they could come and assist me, trying to convince me to have my meals. and by doing so, I would recover soon. And these people work together to help me to have my regular meals. And indeed, after having these regular meals, I can read the books more regularly than before. And I can also be communicated with them better, and everyone says that they are doing their best to make sure that I recover. That's all.
Thank you very much, Mrs. Yang Tirith, for responding to the questions. Thank you.
One question, please. Without telling us too much detail, if you could just answer to a general question, if you are aware of any security guards in the vicinity. Is there any security regime that is applied to you?
Response. I can see that everyone can agree with me that there is no security personnel here. I think I live a normal life here in Cambodia because I don't think that I would be treated as someone who requires security or protection. And for those who can speak Khmer, they can come and approach me and talk to me because I indeed understand English significantly. So they know that I can speak a foreign language. That's all.
Of course, we know that. I was just wondering whether it would bother you if the security checks were imposed pursuant to the prosecutor's request.
They just started. I began to do it. The place where I live was surrounded by foreigners. And our neighbors were of the view that their children were educated. So wherever they had difficulty, we assisted them. And my Cambodian compatriots also assisted me a lot. As such, our French friends who resided close to me assisted all Cambodians, the Cambodian who has suffered from illnesses. So they were very helpful. They helped us a lot.
Thank you very much, madam. Yeah. Do you like receiving visits? Do you like to receive people, or you rather prefer to be left alone?
I don't want to be left alone. When I came to work downstairs, there were people, foreigners, who came to work with me. Is that correct? They came to work with me, these people.
Yeah. Thank you.
President. The Chamber wishes to retire to the deliberation room for 5 minutes, and security guards are instructed to take care of the accused if the accused can stay behind in this courtroom, but otherwise security guards may bring the accused to the holding cell downstairs. All rise.
Say